Ever find yourself watching one of those, tense courtroom dramas on TV?
Oh, yeah.
And then suddenly you're like hours deep online trying to figure out some legal thing.
Definitely happens. You're not alone there.
Well, today we're actually wading into a real-world situation that's got a lot of that online buzz going. Feels almost like it's pulled from a script, really, involving all the ongoing discussions around Justin Baldoni.
Exactly. And what really caught our eye, and probably yours too, is this thing people are calling a subpoena. It's this document that supposedly links Blake Lively and Ryan Reynolds to trying to get text messages from, well, someone referred to online as Jones.
Right.
It's quite a case study in how fast information, and sometimes, let's be real, misinformation can just spread online like wildfire.
Absolutely. This whole thing seems to have kicked off with a post somewhere online, and that's where we kind of come in. We're putting on our investigative hats today to really dig into the details. Our mission, basically, is to look at this alleged subpoena, try to separate the facts from, pure speculation.
Yeah. And figure out what this legal step, if it is even that, might actually mean in the bigger picture. We know folks listening might have different levels of legal know-how, so we'll keep it clear. Avoid the jargon where we can.
Sounds good.
Okay, so this alleged subpoena. Let's get into it.
Let's do it. So the initial post that got everyone talking mentioned this infamous subpoena supposedly filed by Lively and Reynolds. The goal, getting these texts from Jones.
Okay.
But what's interesting is, right away, looking at the online talk, there was a lot of skepticism, like significant skepticism.
That's good, usually. Means
Right.
people aren't just swallowing it whole.
Right. It wasn't just accepted, which, yeah, always a good sign when you're sorting through online stuff.
So what were the first, red flags?
Well, one of the first things that popped up was about the source, the person who apparently first shared this document.
Yeah.
Apparently, they have a bit of a, let's say, track record for maybe not always sharing the most accurate information.
Yeah? Yeah, there were even mentions of past times where info was maybe
Yeah.
creatively adjusted.
Creatively adjusted. Okay, that definitely makes you raise an eyebrow.
It does. And sort of building on that, someone else mentioned a video looking into it. It suggested that this whole legal approach, I mean, even if it was technically allowed,
Yeah.
it might be a pretty unconventional way to go about things.
Huh. So if it's real, why do it that way?
Exactly. Makes you wonder.
Which then brings us to maybe an even bigger point of doubt. This is where it gets kind of weird.
Oh, yeah.
The focus shifts to who's actually named as the plaintiff on this supposed subpoena, a company called Van Zandt Inc.
Van Zandt Inc. This is where you really have to stop and scratch your head.
Wait, Van Zandt Inc.? What is that?
Precisely. The online community really put on their detective hats here. And what they dug up about Van Zandt Inc., well, it raises some pretty serious questions about whether this document is legitimate or even relevant at all.
Okay, so what did they find?
Simple online searches point to Van Zandt Inc. being a New York-based import business. Deals in something specific like industrial supplies or something. Definitely nothing to do with entertainment law.
Imports. Not exactly Hollywood lawyering.
Not at all. And no apparent connection to Blake Lively or Ryan Reynolds.
But wait, it gets stranger, right? I saw something about the timing.
Oh, absolutely, stranger.
Yeah.
The dates. The company was incorporated before Lively and Reynolds were even a couple.
No way. So unless they had some kind of super long game legal strategy involving an import company before they even got together.
Which seems unlikely.
Highly improbable, yeah. So the main takeaway here is just this huge disconnect. This company, Van Zandt Inc., it strongly suggests this infamous subpoena might just be, well, a dud.
Right. Raises serious questions right off the bat about its legitimacy.
And didn't the address add another layer of weirdness?
It did. The plot thickens, like you said, like a legal drama. The listed address for Van Zandt Inc., it seems to point to maybe a co-working space.
Like a WeWork or something.
Possibly. Or maybe a suite in a building that also houses an investment fund. And kind of randomly, a nonprofit linked to Malala Yousafzai.
Wow. Okay. That is quite the mix.
It really is. And none of it screams high-profile celebrity legal case.
So the conclusion online seems pretty logical then. Van Zandt Inc. has basically zero connection to this whole situation.
That seems to be the strong consensus, yeah.
Which then makes you ask, is this document just completely made up? Like a phantom subpoena, as some people were calling it?
Or is there some other explanation we're just not seeing?
Yeah, and if there is, it's definitely not obvious.
Which sort of pivots us to another interesting legal idea that came up in the discussion, this concept of does 110.
Okay, does 110. Sounds like something from an old detective show.
Huh. Yeah, it does a bit. But it's actually a real legal thing in New York and other places too. Think of it like, someone committed a foul in a game, but you don't know their name yet.
Right.
You can file against John Doe, or in this case, does 1 through 10, as placeholders. It lets you start the legal process, start investigating to figure out who they actually are.
Okay, let's unpack that a bit more. We saw some comments from people with, like, law school backgrounds explaining this. They said filing against unnamed defendants, these does, is a way to just get the ball rolling legally. When you think something wrong happened, but you haven't pinned down exactly who is involved yet.
Exactly right. It's like saying, hey, we think someone did something wrong here, and we're going to use the legal system to find out who.
So the alleged subpoena, if it were somehow legitimately connected to a real does 110 case.
Right, yes.
It could theoretically be a tool to gather info to identify those does, like part of that initial fact-finding.
Precisely. It could be part of that legal fact-finding mission, working within those procedural rules.
And this is the big but.
The huge but. The Van Zandt Inc. issue just throws this massive wrench into this specific document's credibility as being part of that process.
Right. The idea of a subpoena in a Doe case might be legit, but this particular document seems off because of Van Zandt Inc.
Exactly. And this is where the idea of subpoenaing third parties comes in, like the entity people are calling Jones' work.
Okay.
The thinking is, once that initial Doe case is active, you can potentially subpoena third parties who might have information that helps identify those unnamed does.
So you're not necessarily going after Jones' work themselves, but you think they have info about the does.
Correct. You're seeking documents or communications they might possess. And importantly, at least how it works in New York, you often don't need a judge's permission right away to issue these third-party subpoenas.
Oh, okay.
It's more a procedural step the lawyers handle, which might explain why these things don't always pop up on the public court record immediately.
Unless someone challenges it. Right.
Exactly. Unless there's a dispute or a motion to quash it, it might not be filed publicly right away. So that could explain why this document only surfaced through, this online post rather than official court filings.
Okay, that adds another layer. So what about the potential strategy here? People were speculating online.
Yeah, that was fascinating. The discussion raised this possibility. Maybe Lively and Reynolds' legal team used information gathered from this New York does case if it was real, if the subpoena was tied to it.
A lot of ifs.
A lot of ifs. But if they got info, maybe they used it to then file a different lawsuit, or perhaps what's called a CRD complaint is with a regulatory body somewhere else. Specifically, California came up.
Wow, okay. So like using one state's process to gather ammo for action in another state.
Potentially. It's like a legal chess move.
Yeah, it really is. But was that the plan all along? Or did they maybe get the info first and then decide to pivot to California?
That's the million-dollar question, isn't it? We don't know. It hints at, legal strategy evolving as you uncover information.
Okay, so we've got the initial online buzz, the big red flags about the source, and especially Van Zandt Inc. And now this potential legal strategy involving Doe defendants and maybe crossing state lines.
Right. Even if this specific document is questionable, the underlying legal concepts are worth understanding.
Definitely. So let's circle back to the main point people were stuck on. How would a subpoena in a case against unnamed does actually get you text messages from Jones' work? It still feels a bit indirect.
It does seem counterintuitive at first glance, but the key, again, is supposedly identifying those does.
Okay.
The argument would be that Jones' work, as an entity, might have communications, texts, emails, whatever, or documents that could help point the finger at who those does 1 through 10 actually are.
So the subpoena's stated purpose wouldn't be give us Jones' work's texts, but more like give us information you possess that helps identify these specific unnamed people.
That would likely be the framing, yes. It's targeting information about others that this third party happens to hold.
And like we said, these often aren't filed publicly unless challenged, which could be why it wasn't found in official records easily.
Correct. Adds to the mystery of how this specific document surfaced.
Okay, so this all then leads to the really crucial question, the so what question.
The bottom line.
Even if this whole setup, the does lawsuit, the subpoena to a third party like Jones' work, even if that's all a legit legal tactic, what's the actual practical outcome?
Yeah. Does it mean the case gets thrown out? Do the texts get excluded later? What does it do?
Because those are the questions that really count in the end.
And the perspective shared online, which seemed quite pragmatic, was, well, maybe not that much.
Oh, how so?
The suggestion was, look, these text messages, they were probably going to come out during the normal discovery process anyway, if a case moved forward.
Ah, right. Discovery, where both sides have to exchange relevant documents and information.
Exactly. So while everyone online is dissecting this specific subpoena attempt, it might be putting way too much emphasis on one procedural step.
Like focusing on how the mail carrier delivered the letter instead of what's actually in the letter.
That's a great analogy. Yeah. It might not fundamentally change what information eventually comes to light. So all this online debate might be about basically the legal equivalent of a strongly worded opening move before the real arguments even begin.
Interesting perspective. Take some of the drama out of this specific document, maybe?
Potentially. Now, adding another twist to the timeline, there was information shared suggesting that this original lawsuit against Does 110, the New York one, apparently was discontinued, dropped.
When?
Around mid-December, which is notably around the same time a major newspaper published a big article related to the whole situation.
December 19th discontinued, December 22nd article. That timing is interesting.
It certainly adds to the intrigue, doesn't it? It makes you wonder about the connection between that initial legal filing, its discontinuation, and what happened next.
Definitely. But then, just when you think you're getting a handle on it, there's a strong counter-argument, right? A totally different take on this document.
Yes. A very strong counter-narrative emerged. And this one really throws cold water on the whole thing.
What's the gist?
The suggestion here is that this document being passed around, it might not even be a subpoena.
Not a subpoena at all. Then what?
Possibly a summons. And not just any summons, but one related to a corporation. Maybe Van Zandt Inc., maybe another that was actually dissolved years ago.
It's a summons for a defunct company.
That's the claim. And quite alarmingly, this perspective suggests the document might be being spread intentionally by a source known for, well, disinformation. And even doxing people.
Whoa. Okay, that's a serious accusation. Disinformation and doxing.
Very serious. Yeah. And it highlights the potential dangers here. This counterargument also pointed out, again, that the name on the document doesn't seem to be Blake Lively's actual legal name.
Right. Another inconsistency.
And as we've hammered home, the named company, Van Zandt Inc., seems totally unconnected.
So this whole counter-narrative basically says, warning, this document is likely fake, irrelevant, and possibly spread with bad intentions.
That's pretty much the takeaway from that side. It really underscores why you have to be so careful with documents that just appear online, especially from murky sources.
Man, it's kind of ironic, though, isn't it, looking at the online reactions?
How so?
Well, a lot of the outrage seems focused on the people who were legally trying to get information.
On Lively and Reynolds, potentially using legal means.
Yeah. Instead of maybe focusing on the people who allegedly sent the problematic texts in the first place, it's like the internet's priorities got skewed.
That's a really sharp observation. Some commentators pointed that out. The anger seems misplaced.
Focusing on the process, not the alleged substance.
And someone else made the point. Imagine if Justin Baldoni had used similar legal tactics.
Ooh. Yeah.
His supporters would likely be praising it, right?
Yeah.
Calling it smart, strategic, necessary.
Good point. Highlights a potential double standard in how these things are viewed, depending on who's doing it.
Definitely. And ultimately, the sort of prevailing view from those looking at it legally online seemed to be, look, focusing on these standard legal documents like they're some kind of bombshell smoking gun.
Yeah.
It's probably a massive overreach. If anything, the fact that this is what's being debated might actually suggest Lively's team acted within the law.
Because if there was something truly scandalous in how they got the info, maybe that would be the focus.
Possibly. It suggests maybe they just followed standard, perhaps less common, legal procedures.
Okay, wow. So let's try and wrap our heads around this, bringing it all together from this deep dive. What are the key takeaways?
Well, first, this alleged subpoena. It seems likely tied, conceptually at least, to an initial lawsuit filed in New York against these unnamed Does 110.
Which is a known legal strategy, a way to start investigating.
Right. A way to gather info, potentially for future legal action, maybe elsewhere.
However,
the named plaintiff on the specific document floating around, Van Zandt Inc., appears totally unrelated, which casts huge doubt on the authenticity, or at least the relevance, of that particular document.
Got it. So the strategy exists, but this piece of paper might be suspect.
Precisely. And really shows how complex legal procedures are. They could be easily twisted or misunderstood when they hit the wilds of online discussion boards.
Yeah, they get sensationalized really fast.
Definitely. And the actual impact of this specific move, assuming it was real and tied to the Doe case on any future cases or whether texts are admissible, still totally unclear.
Because it was likely just an early step, a procedural thing.
Exactly. Just one small step in what's probably a much larger, more complicated situation.
So this whole episode really makes you think, doesn't it? What does all this intense online focus on these legal filings actually tell us about the public's interest here?
That's a great point. And maybe more broadly, what are the challenges we all face trying to make sense of complex legal stuff when it's being picked apart online outside of a courtroom, often without full context?
Yeah, it's tough. It really leaves you wondering about just the power of online information, how narratives catch on so quickly, even if they're based on stuff that might be flawed or misinterpreted or maybe even deliberately misleading, like that counter-narrative suggested.
Right. What does it say about our collective desire to understand these things, even when the legal details are, frankly, pretty dense and maybe beyond a quick online read?
It's definitely something to chew on. A lot to think about there.